Good morning. My name's Lorna Gamel. I am the Employment Law and HR Training Manager at Law at Work. Some of you will know me from previous employment law updates. Of course, this one's a little bit different. Just before I launch in, could somebody perhaps reply in the chat section and just confirm that you're able to hear me okay? Okay, thank you. Right, let's start off then. What I'm going to do is share my screen with you. So in order to do that, I will move across now to a PowerPoint presentation. Now, because I'm at home working like I'm sure a lot of you are, I am able to see two screens at the one time, which means that I will need to be able to access only the presentation at the moment. I'll not be able to see any of the comments that you're putting in the chats section. However, I will come back later on when we get to the end of the session and just check to see what questions have been asked, and hopefully I'll go through some of those at that point. So let me just share my screen with you now. Okay. So today we are going to start off by thinking about some legislative developments. Now, clearly in the last couple of weeks, there's been quite a few new pieces of legislation introduced to deal specifically with the coronavirus. We're not going to cover those off in any detail today. The purpose of this session is really a replacement for the employment law updates that we had to cancel down in London and up north as a result of coronavirus. However, there will be hopefully around about 20 to 30 minutes left at the end of the session when I can answer any coronavirus questions that you may have. I will also share with you the location on our website where you will be able to find lots of really useful information about the coronavirus and its implications from an employment law perspective. So the legislative developments that we'll focus on today are non-coronavirus related. One important development since our last employment law update is the publication of the Equality and Human Rights Commission guide on sexual harassment and harassment at work. So that's a pretty substantial topic. The guide itself is relatively short. However, the technical guidance that accompanies that is 84 pages long. So of course today it'll just be a bit of a whistle-stop tour through the main steps that the guide suggests. Then we'll move on to think about some key cases that have occurred in the last 6 months or so, some employment tribunal cases on unfair dismissal and discrimination. And as I say, hopefully at the end we'll have plenty of time for questions. Perhaps not so much the discussion, given that we can't all have a chat with one another, and those questions can be related either to the matters that we're talking about today, to coronavirus, or to any other employment law related topic. Okay, so starting off with legislative developments. Okay, so coming up in April, which is now, although these developments are mostly due to come into force on the 6th of April, which is Monday. So the first important development to be aware of, and this will affect all employers, is that a written statement of particulars must be provided to all workers joining the organisation. And just to emphasise the word workers there, so this is taking us beyond the current obligation, which is to provide a written statement of employment particulars to employees. And one big change here is that the statement will have to be provided on or before the start of the engagement, which is different to the current position where employers have 2 months after the start of the employment relationship to provide that information. There's also been an expansion of the categories of information which have to be included within that statement. The next couple of developments relate to agencies and also those organisations who utilise agency workers. If you do utilise agency workers, you might be familiar with what's called the Swedish derogation in the agency worker regulations. So one of the main purposes of the agency worker regulations is to try and achieve equality of terms with agency workers and directly hired employees of the organisation. And so what that means in practice is that after a period of 12 qualifying weeks, agency workers become entitled to equality of terms with directly hired employees of the end user. And that's unless the Swedish derogation applies. And the Swedish derogation applies where the individual is engaged in a permanent contract of employment with the agency and is paid a minimum amount between assignments. That Swedish derogation has been quite useful for lots of organisations. However, it is being abolished from Monday. If this is something that affects you, hopefully this has been on your radar for some time and you've been planning for this, and we have told you about this at previous employment law updates. And any individuals who are affected by this change should be notified by their agency in writing by the 30th of April. Agency workers must also be provided with a key information document. That document will have to contain certain categories of information, things like who they will be paid by, how much they will be paid, what their hours will be, and whether there will be any deductions from their pay. And this is really to try and improve transparency in atypical or casual employment relationships. And that's something that we'll come back to talk more about shortly. The government has been keen for some time to encourage employers to better utilise arrangements for information and consultation. So the threshold for making such a request will be lowered from 10% of the workforce to 2% of the workforce from Monday, subject to the existing minimum of 15 employees. The next development will be important for organisations who engage individuals on variable hours contracts. From the 6th of April, the way in which holiday pay for those individuals will be calculated changes. So instead of the current 12-week reference period being used, that will be extended to 52 weeks. And the idea here is to make the calculation of holiday pay fairer for workers in situations where there are peaks and troughs in their workload across the course of the year. Hopefully, if this change affects you, you'll be prepared for this, because of course you will need to now use data which is almost 1 year old. Just in the last week or so, the final version of the parental bereavement leave and pay legislation has been approved, and this gives bereaved parents the right to up to 2 weeks of leave, and in some situations pay in the event that they sadly experience the death of a child or a stillbirth after 24 weeks. The leave is a day one right, so any employee who is engaged by you will be entitled to take that leave if they qualify for it, regardless of their length of service. The pay is contingent on the employee satisfying certain criteria, and they have to have, for example, 6 months service, and they have to meet the lower earnings threshold for national insurance purposes. The leave can be taken at any point within the 56 weeks that follows the bereavement, and it can be taken either as 1 2-week period, so 2 consecutive weeks, or the 2 weeks can be separated and taken individually. It will come as a relief to some organisations to learn that the new compliance measures in relation to the IR35 rules have been delayed until next year. Those were due to come into force on the 6th of April, and lots of organisations up and down the country were scurrying about trying to make last-minute preparations for the change in the rules, when of course coronavirus hit and our lives have been turned upside down. So the government, I think, felt it was only fair to delay the introduction of the new measures in order to allow organisations a little bit more time to prepare. Just for those of you who aren't familiar with the change, essentially what's going to happen is that the responsibility for designating the tax status of contractors will shift from the individual contractor to the organisation, and the organisation who engages the contractor will become responsible for designating the tax status of the individual and for making sure that the correct amount of tax is deducted and accounted for. Okay, so in the Queen's speech in December, it seems like a long time ago now, given everything that's happened since then, the government told us about some of the legislation that they plan to introduce in the current parliamentary session. This legislation, of course, is a little bit up in the air, I suppose, given that we don't know how timescales will be affected by the current coronavirus situation. So what I'll do is I'll just take you through these briefly. Some of them you will already be familiar with because they're not really new in the sense that we have been speaking about the possibility of these developments occurring for some time now. Okay, so the first one is the introduction of a single labour market enforcement agency. At the moment, there are 4 main bodies who enforce employment rights in the UK, and the proposal is to amalgamate those organisations into one single labour market enforcement agency, whose purpose will be twofold. The first will be in order to make sure that vulnerable workers are aware of and can assert their employment rights. And the second is to provide support to organisations in complying with employment law. The consultation in relation to that development finished on the 9th of October last year, and it remains to be seen what the timescales are for the introduction of this new agency. Again, tips and service charges being paid in full to workers is a development that we've spoken to you about at previous employment law updates. This is something which has been on the agenda for some time. The trade unions have campaigned heavily for organisations to distribute tips and service charges in a fair and transparent way. The government subsequently conducted an investigation into this problem. And now it's proposed that legislation will be introduced accompanied by a statutory code of practice. I mentioned when I was discussing one of the points in the first slide, the idea of atypical or casual arrangements being addressed, and in particular there being more transparency surrounding those. So this next development is related to that aim, and it arises as a result of the Good Work Plan, which we've spoken to you about before. So what the government wants to do here is to give those who are on, for example, 0 hours or casual contracts, the right to request a more predictable and stable contract after a qualifying period of 26 weeks. Moving on to the next development, again, we've spoken to you about this one at previous updates. There was a consultation carried out in order to consider whether the protection from redundancy, which currently applies in some maternity situations, should be extended, and it looks like that will now happen. So the protection will begin when the individual notifies their employer either verbally or in writing of their pregnancy, and will carry on until 6 months after a return from maternity leave, so substantially increasing that period of protection for those who are pregnant or on maternity leave. Again, there was a consultation carried out in relation to a proposal to provide leave and pay for individuals who have babies in neonatal care, either because they were born prematurely or are otherwise unwell. We don't have any further details of the specifics at this point, although it may well be a similar right to bereavement leave or pay in the sense of the leave not having any period of qualifying service attached to it, and the pay possibly having some criteria. In the Conservative Party's manifesto, they suggested that they would like to extend leave for unpaid carers to 1 week. Now, it really is just a sentence in the manifesto, really without any further detail behind it. So We don't know whether this leave will be a general entitlement or whether it will be for emergency situations. And we also don't know what the definition of an unpaid carer will be. So will it be people who have caring responsibilities for adults, or will also apply to parents? These are question marks at the moment, and we'll be interested to find out more detail in due course, although it might be some time before these proposals are now making their way to the top of the agenda. And the Conservative Party has also for some time been keen to try and promote flexible working, and so there's a suggestion that flexibility will be made the default, so organisations will be expected to allow flexible working, and there will have to be a good reason for departing from that general practice. And I'll just briefly go through some of the other employment-related items that were contained within the Conservative Party manifesto. So there's no specific legislation in the pipeline in relation to these things. However, because they have been highlighted as being agenda items for the Conservative Party, it gives us an idea of what we might expect to see in the coming years. So the Conservative Party has said it's committed to considering how to make it easier for fathers to take paternity leave. I think that problem could be resolved quite easily by addressing the pay issue, because as studies have shown time and time again, the main barrier to fathers taking up paternity leave is the very small amount of statutory paternity pay, which is required as a statutory minimum. And the government plans to publish a national disability strategy before the end of this year. Now, that timescale was given at a point before coronavirus reared its ugly head. So again, this might be something that slips a little bit. What's quite interesting, I think, about this national disability strategy is that it's anticipated to be very wide-ranging in nature. So by no means will it only relate to the employment relationship. However, the government has given us a little bit of an indication that there could be some quite robust measures introduced from the perspective of employment rights. In particular, the government has said that they want to ensure that employers are playing their part in keeping disabled employees and those with health conditions in the workforce. Now, to me, the duty to make reasonable adjustments in the other forms of disability discrimination that apply are already quite onerous on employers. There's already quite a lot of risk associated with engaging people who have disabilities. Employers need to be very careful that they don't fall foul of the rules. So I think some organisations will be a little bit worried that this new disability strategy might result in further obligations, which will then highlight those risks further. The government wants to reduce the disability employment gap and has committed to trying to increase the number of disabled people in the workforce by 1 million between 2017 and 2027. So that work is already ongoing. And then just a few final points. The government wants to improve incentives to tackle the problem of excessive executive pay and rewards for failure. And you might recall that I think a couple of updates ago we spoke to you about the possibility of a CEO pay gap reporting system being introduced, comparing the pay of the CEO to average pay within the organisation. And that specific proposal hasn't been taken forward. However, that might be one of the mechanisms that the government considers to try and tackle the problem of excessive executive pay. The government wants to ensure that redundancy payments can be clawed back when highly paid civil servants move between jobs, and that's obviously in response to a specific problem which has been identified. Ensure a more robust approach when employers abuse employment law, for example, failing to pay statutory sick pay, and help for employers to invest in skills and consideration of how the working of the apprenticeship levy can be improved. And then finally for this section, I just wanted to put on your radar the proposals that we've spoken to you about previously at our employment law updates, which are currently stalled for the time being. So you may recall that I think at our last employment law update, we talked to you in quite a lot of detail about the government's plans to tackle the misuse of confidentiality clauses, to try and bring in new legislation to make sure that confidentiality clauses in contracts of employment and settlement agreements can only be used in certain situations, and to require legal advice to be taken before an individual signs up to a confidentiality clause, together with new enforcement mechanisms. So no further developments in relation to that for the time being. The Good Work Plan, which we've spoken to you about in the past, resulted in a number of different proposals, and one broad headline point which covered a number of those different proposals was to address one-sided flexibility in certain employment relationships. And when we talk about one-sided flexibility, what we mean is where one party, very usually the employer, has all of the flexibility, and the other party, usually the individual, doesn't. So where there's a kind of skew in the power balance of the relationship. Only one of those proposals has been taken further for the time being, and that is the plan to allow for individuals to request a more predictable and stable contract of employment after 26 weeks service, and I spoke to you about that briefly already. You may recall that some of the other proposals which have stalled for the time being were things like requiring organisations to give a minimum amount of notice to individuals of their shifts, and paying compensation to workers where their shifts are changed at short notice or curtailed once they've started. Those proposals were quite worrying for a lot of organisations in particular sectors who rely heavily on that flexibility, for example, the care sector. So it will come as welcome news to those organisations that these proposals haven't been taken any further for the time being, at least anyway. The rest of the proposals on this slide all relate to the government's wide-ranging study on gender equality, and you might remember, if you attended our last employment law update, that some of the suggestions were strengthening the equality legislation, closing the gender pay gap, reviewing the shared parental leave system, restructuring family leave and pay, and requiring employers to publish their family-friendly policies. So some really quite chunky aims there. So it's perhaps no surprise that those haven't moved on significantly since last time we updated you, and it may well be that they're on the back burner for quite some time now. Okay, so we'll move on now to think about the Equality and Human Rights Commission guide on sexual harassment and harassment at work. So we'll start off with a few general points about that. So the guide describes itself as the authoritative and comprehensive guide to the law and best practice in tackling harassment. It's described as user-friendly and accessible, and I have to say, having read the guide and the associated technical guidance, I would agree that it is user-friendly and accessible. It's written in really straightforward language, very easy to understand, well structured, plenty of headings and bullet points. So even if you do decide to read the 84 pages of technical guidance, it shouldn't take you too long to do that. I think I was able to get through it all and kind of distill the main points within a couple of hours. Now, interestingly, it's described as information and advice as opposed to a statutory code. And this departs from what the government told us originally, which was that they would introduce a statutory code to try and tackle the problem of sexual harassment in the workplace. The fact that it isn't a statutory code means that the status of it is unfortunately lower than what it would otherwise have been. So what that means in practice is that employment tribunals will not be bound to take the guide into account when they reach decisions. However, of course, it is likely that it will still be considered by the employment tribunal. And you can imagine that the solicitor representing the claimant in a harassment case will want to carry out a comparison exercise, thinking about what the guide suggests in comparison to what steps the employer has taken. And of course, if there are any gaps, it's likely that they will be used as ammunition by the claimant's solicitor to argue that the employer is liable for the harassment because they've not done everything that the Equality and Human Rights Commission suggested that they do. Just before we move on, what I should say is that there were a number of other proposals which were in the pipeline in order to try and tackle the problem of sexual harassment. You might remember that some of those were increasing the time limit for raising claims under the Equality Act in the Employment Tribunal, extending the protection available to volunteers and interns, and also creating a statutory duty to protect employees from sexual harassment. There haven't been any further developments in relation to those for the time being. This new guide is really the only firm proposal which has been taken forward. The Equality and Human Rights Commission, I think at the beginning of last year, carried out a study called Turning the Tables, designed to try and assess how widespread a problem harassment in the workplace is. And on the slide now, hopefully you should see some of the statistics. So nearly 3/4 of those who responded said that they had experienced sexual harassment. And whilst we know that sexual harassment is a problem which affects women and men, what this study showed us was that nearly all of those who had been sexually harassed were women. And actually, just to drill down into a little bit more detail, by far and away the most common demographic for sexual harassment was the sexual harassment being perpetrated by a male with management responsibilities towards a junior female colleague. Just under 1/4 said that they had been harassed by a third party. And when we talk about a third party, what we mean is somebody who your employees come into contact with as part of their duties, but who isn't a colleague. So depending on the sector that you work in, it could be a customer, client, service user, patient, pupil. Now, this statistic is a lot higher, I think, than what a lot of people had anticipated. And as a result of that, and we'll come on to look at this in more detail, the guide contains some quite specific and wide-ranging proposals in terms of how employers should tackle the problem of third-party harassment. Around half of those who responded hadn't reported the harassment to anyone at work, and we know that that is a common theme when it comes to sexual harassment. Often there are barriers which prevent victims of sexual harassment from reporting that either informally or formally to their employer, and that's something we'll talk about a little bit more when we come on to look at the steps that the guide suggests. Now, the guide doesn't just relate to sexual harassment, it also relates to other forms of harassment under the Equality Act. So we have some statistics here that relate to those other forms of harassment. So 1 in 5 mothers said that they had experienced harassment or negative comments related to pregnancy and flexible working. Nearly 7 out of 10 LGBT people said that they had been sexually harassed at work. Over 70% of Asian and Black workers said that they had experienced racial harassment at work in the last 5 years. Those under 25 are double as likely to feel harassed because of their age than any other age group. And 24% of disabled people said that they felt their disability was treated negatively in the workplace. So a few general points in relation to the guide before we delve into the 7 steps which are suggested by the guide. The headline point is that employers must take reasonable steps to prevent harassment. And this is very similar to the wording contained within the Equality Act, which relates to an employer's statutory defence. And some of you will know already that an employer will have a statutory defence to a claim of harassment by one employee towards another if they can show that they took all reasonably practicable steps to prevent that harassment from occurring. What will be reasonable will vary from employer to employer. There's no one-size-fits-all approach, nor is there a prescribed minimum. So of course that means that there's a bit of judgment involved when the employer is thinking about what steps they will take. The guide applies to all employers. There's no minimum number of employees before the guide becomes applicable. However, what will be reasonable for a small employer may be different to what will be reasonable for a large employer. In deciding whether a step is reasonable, the employer should consider the likely effect of the step and whether an alternative step could be more effective. And I often think about this, of course, from the perspective of training, given that that is my focus. Clearly, there's a range of different training options available to organisations. We have e-learning, for example. Short e-learning modules normally last around about, say, 20 minutes. Scaling that up, you could have a lengthier face-to-face session, might be a large group session where information is delivered to individuals and they have the opportunity to ask questions. And then scaling that up further again, you might have, say, half-day or full-day workshops where employees are able to participate in a range of different activities and exercises and are able to enter into more in-depth discussions. So clearly, when presented with a range of options like that, the employer has to balance up both the effectiveness of the step and also other factors that are relevant to them. And we see some of those factors on the slide now at the top of that, the first bullet point. So things like time, cost and potential disruption. Of course, tribunals recognise that sometimes certain steps aren't practical, and perhaps where the employer has limited resources or where they have a very geographically dispersed workforce. If an employer knows that an employee has previously committed harassment, then they may be required to take specific steps in relation to that employee. So it might be, for example, that the employer delivers general dignity at work training to all employees annually, but where there is a specific event, for example, a grievance related to racial harassment, then one of the outcomes of the grievance process might be that the alleged perpetrator has to carry out some diversity training. Now, carrying out an effective investigation after harassment has been reported is obviously important, but it's not enough to satisfy the reasonable steps test. As what the guide is focused on here is employers taking preventative action. So employers really are very much expected to be proactive in terms of thinking about the steps that they can take to prevent harassment from occurring in the first place. Of course, taking complaints of harassment seriously is important in trying to prevent further acts of harassment. If a particular complaint of harassment is dealt with seriously, then it sends the message to the people involved in that the employer considers harassment to be a very serious matter. The guide is at pains to emphasise that the obligation on the employer is an ongoing one. This isn't a one-off exercise. There are various ways in which organisations are expected to assess the effectiveness of their steps. And also what's important too is that organisations are alert to the introduction of better ways of doing things, and that might mean that technology plays a role. Also, if the workforce changes, that might be a prompt to take different steps. So, for example, if the organisation becomes more racially diverse, then additional steps may be required in order to ensure that there's no racial harassment in the workforce. Okay, so as I said earlier on, there are 7 steps contained within the guide, so we're going to talk about those all relatively briefly. It might be as a result of this being put on your radar, you want some more in-depth training for your managers on this, and of course that's something that we'd be able to help you with. Okay, so step 1 is to develop an effective anti-harassment policy. And no doubt all of your organisations will have some kind of policy in place which makes it clear that harassment is a serious disciplinary matter. It might be a dignity at work policy, it might be an anti-harassment, bullying and victimisation policy, it might be an equal opportunities policy. And what it's called isn't important. However, what is important is that the policy contains all of the required information. And having reviewed a lot of these types of policies in my time, what I can say is that my view is that most policies are unlikely to comply with the requirements of the guide. And that's really just down to the sheer amount and detail of information that the guide anticipates will be included in your policy. So having gone through the guide in a lot of detail, I'll just give you a couple of examples of information which I think most employers' policies currently omit, but which should be included. It should be made clear within the policy that third-party harassment isn't tolerated and what steps will be taken in the event that third-party harassment does arise. And it should also be clear in the policy that conduct which takes place outside of the workplace can amount to harassment under the policy and therefore be a disciplinary matter. Now, those are just two examples. There's many other categories of information which, in my experience, most policies omit, which should now be included. For those of you who are our clients, our template style policies have been updated and you're able to locate those in the client area of our website. So you can either use those to do a bit of a comparison exercise with your current policy, or if you already use our style policy, then you might want to just adopt our new style. It will require some tailoring though, because one of the other things that the guide makes clear is that a one-size-fits-all approach is not appropriate, and that policies should be tailored to the organisation, including the sector that the organisation belongs to. For example, the examples that you give within your policy of the different behaviours which could amount to harassment should be relevant to your organisation and to the people who work within it. Of course, having a policy on its own isn't enough. The guide also contains information on how employers should ensure an adequate level of awareness of the policy. So, for example, things like features in staff newsletters and discussion at team meetings, just to continually reinforce the importance of the standards contained within the policy. And there's also an expectation that employers will monitor the effectiveness of their policy. Step 2, engage your staff. So as we discussed briefly earlier on, non-reporting in particular of sexual harassment is a real problem, and therefore the guide suggests that employers take steps in order to ensure that managers engage their staff such that staff members feel able to confide in their manager if they are experiencing harassment. So that could be things like having regular one-to-ones, team meetings, return to work interviews after periods of absence. Of course, it's important that employees also have an opportunity to check in regularly with somebody who's not their manager in case it's the manager who's the perpetrator of the harassment. And organisations are also expected to train their managers on how to be alert to signs of harassment. So things like an increase in sickness absence levels, perhaps tension in the workplace, lower productivity. Step 3, assess and take steps to reduce risks in your workplace. What's envisaged here is, I suppose, a risk assessment in the same type of way that an organisation would carry out a risk assessment for other health and safety purposes, trying to identify what the particular risks of harassment are in your own workplace, and then putting in place measures to try and mitigate those risks. Examples of risk factors would be people who work in a way which makes them vulnerable in terms of employment status. So it might be volunteers, interns, trainees, those who have limited rights and who are therefore less likely to rock the boat by raising concerns about harassment. Other examples would be the presence of alcohol in the workplace, so for example in the hospitality sector. And then a final example would be an imbalance of power. And for those of you who have seen the recent film Bombshell, you'll be aware of how power imbalances can allow sexual harassment in particular to manifest itself within the workplace. What we had there was an example of a very senior male, the chief executive, I think, of Fox News in America, allegedly sexually harass a large number of very young female colleagues who were new to the media industry and who were looking to kind of make their way and progress up the ladder. So you can see why that enormous imbalance in power creates a risk. Step 4, reporting. The guide suggests that organisations introduce, if they don't already have this, an online or externally run reporting system in order to allow employees to make either named or anonymous complaints of sexual harassment, and other forms of harassment as well, of course. So some of you will already have a whistleblowing hotline or helpline, and it's a little bit similar to that, I suppose. It just gives the employee an alternative reporting mechanism out with your usual grievance process. Now, of course, anonymous complaints can be very challenging to deal with. You don't, of course, have all of the information that you need in order to investigate the complaint thoroughly. However, the idea here is that it's better to have some information than no information at all. So if the ability to make an anonymous complaint results in you receiving information which you wouldn't otherwise have been able to receive, then it's a positive thing. And despite not being able to investigate the complaint in the same way as you might otherwise be able to, often there are some steps that you can take in order to try and address the issue. So it might be that the receipt of an anonymous complaint triggers you to refresh your equal opportunities or your dignity at work training, or perhaps prompts you to put in place more targeted monitoring of a particular team or department. And of course, the person who takes the call or who responds to the anonymous report is able to explain to the individual the steps that they can take if they do decide that they want to make a named complaint, and the safeguards that are in place in order to ensure that they are protected if they do that. Step 5 is training. So this, of course, is something that I've looked at in quite a lot of detail. What is expected is training of 3 different categories of people within the workplace. So all employees are expected to be trained on how to recognise harassment, and that would include explaining the different types of behaviours which could fall into the different categories of harassment under the Equality Act. They should also understand what to do in the event that they do experience or witness harassment, and that might be harassment by colleagues or managers, or it could be harassment by third parties who they come into contact with as part of their duties. The second category of training is for managers. So not only should managers be trained in all of the different things that I've mentioned there, managers should also understand how to support people through the process of complaining about harassment, how to investigate a complaint of harassment in a sensitive way, and they should also be aware of the disciplinary issues involved when it comes to complaints of harassment. So they should have some guidance on when it would be appropriate to uphold a finding, or uphold an allegation of harassment, and what the potential consequences of that would be from the perspective of a disciplinary sanction. The guide contains lots of useful information on what to do when a complaint is made, both from an informal perspective and a formal perspective. So covers off things like confidentiality, for example. In step 7, dealing with third parties, I've mentioned this a little bit already. So there's a few different obligations on employers under this step. So as I've mentioned already, employers should have in place a process for dealing with third party harassment, and all employees who encounter third parties as part of their duties should know what that process is. When the Equality Act was introduced back in 2010, there were specific third-party harassment provisions within it. Those were then repealed. There's been talk about reintroducing those. But the point I want to make here is that when those provisions were introduced, we saw a lot of organisations introduce signage where their staff work in public places, for example, shops and on trains, making it clear that any harassment of their staff will be dealt with seriously. So that's the kind of step that's envisaged here, although employers perhaps need to be a little bit more creative in terms of thinking about what else they can do to prevent third-party harassment, and organisations are expected to monitor the effectiveness of those processes. Okay, so as I say, the guide itself, relatively short, the guidance which accompanies that, the technical guidance, much more detailed. So that really was just a whistle-stop tour, but of course for our clients we can provide you with help in terms of implementing those steps. So we'll go on now to talk about a few key cases. We've got 6 cases to talk about altogether, 2 unfair dismissal cases and then 4 discrimination cases. Okay, both of the unfair dismissal cases relate to investigations, and the first one relates to the preparation of the investigation report. So the allegation in this case was that the claimant, who was a professor, had engaged in a sexual relationship with one of the students, and the professor admitted that. And in terms of the university's policies and procedures, the professor could only be dismissed if his conduct fell within the category of scandalous or immoral. An investigation was carried out jointly by a member of HR and a manager. And when that investigation report was concluded, it was reviewed by the university's in-house solicitor. And the in-house solicitor suggested the removal of certain conclusions in the investigation report. So I'm sure some of you will already be aware that the role of the investigator is to establish the facts. The furthest that the investigator should go is to make a recommendation on whether there are sufficient grounds to justify a disciplinary hearing. But the investigating officer shouldn't pass any comment on what the outcome of that hearing should be or what the appropriate sanction would be. And the in-house solicitor here was concerned that the investigators had overstepped the mark. And on that basis, it was recommended that certain conclusions be removed from the report. So that was what happened. And the result of the disciplinary hearing was that the professor was dismissed for gross misconduct. He appealed against that decision, and in the meantime he had made a freedom of information request and had been able to see the earlier versions of the investigation report, which contained conclusions which were favourable to him, the ones that were removed on the advice of the in-house solicitor. So specifically, the investigation report concluded that the professor's conduct didn't fall within this category of scandalous or immoral. So the university appointed an external barrister to conduct the appeal, and the barrister rejected the appeal and suggested that the new information which came out through the freedom of information request didn't alter the fairness of the dismissal. So having been unsuccessful at the internal appeal, the professor went on to raise an unfair dismissal claim in the employment tribunal. And this was quite a lengthy and complicated case, but the upshot was that the conclusion was that the dismissal was fair. The employment tribunal didn't believe that the alteration of the investigation report jeopardised the fairness of the dismissal, and the tribunal was also satisfied that that matter had been properly considered on appeal by the external barrister. Now, of course, in this case, the alteration of the report was confined to bringing the scope of the report back into legal lines. It would perhaps be different if the conclusions were altered in some other way by the in-house solicitor. And you might be familiar with the fact there have been other cases where HR have been criticised for going too far when they've reviewed an investigation report drafted by one of their managers. So it is something that we do need to remain cautious about. Moving on to the next case, Sunshine Hotel against Goddard. I can summarise this one fairly quickly. When presented with a potential conduct issue, often the employer will conduct an investigation into that, and that will usually involve the investigator meeting with the accused employee to get their version of events at an investigation meeting. Now, this case confirms that that step isn't always required, and if it doesn't take place, that won't automatically mean that the dismissal is unfair. This case reminds us that the overall test is whether the dismissal was fair and reasonable in all of the circumstances, and the case suggests that it is plausible that the dismissal could be fair despite there not having been an investigation meeting with the accused employee, assuming that the accused employee was given the opportunity to present their side of the story at the disciplinary hearing and then possibly also a subsequent appeal hearing. In this case, the outcome of this case is backed up by the ACAS Code of Practice on Disciplinary and Grievance Procedures, which suggests that an investigation meeting will sometimes be required. It doesn't state that it's required in all cases. Just a word of caution though, the situation will be different if your internal disciplinary policy or a collective agreement to which your organisation is party requires there to be an investigation meeting with the accused employee as part of every investigation. If that's the case, then of course you should comply with those commitments that have been made within those documents. The next couple of cases will be of interest, I'm sure, because the facts of them are interesting, and the second case that you see on your slide there is one that you've perhaps seen reported in the media. So these cases relate to philosophical beliefs under the Equality Act. And just as a bit of background, one of the protected characteristics under the Equality Act is religion or belief. And it's the belief part of the protected characteristic which is relevant for our purposes. There have been some cases over the previous couple of years which have introduced new philosophical beliefs into the protected characteristic of religion and belief. For example, there was a case in the Glasgow Employment Tribunal last year to the effect that a belief in Scottish independence is a qualifying philosophical belief. And of course, as these cases become known about, they're discussed in the media, it starts to trigger ideas and thoughts of other employees as to whether their own belief could potentially be protected under the Equality Act. Okay, so thinking about the first case there, the claimant in this case was a scientist, and she was engaged on a 2-year fixed-term contract with the organisation. When that contract wasn't renewed, she suspected that that was possibly because of a belief which she held, which she had been quite vocal about on social media. And that belief is that sex is biologically immutable. It's assigned at birth and cannot therefore be changed. And based on that belief, the claimant refused to refer to trans people using the pronouns that were suitable to their new gender. So as I say, she was very critical of trans rights on social media platforms. In particular, she was critical of plans to try and reinforce and develop further rights for trans people. So when her contract wasn't renewed, she raised an employment tribunal claim and argued that the non-renewal was due to her philosophical belief that sex is biologically immutable. And in order to qualify as a philosophical belief, there are certain criteria that have to be satisfied. And in this case, the employment tribunal found that those criteria were not satisfied. There are a couple of issues that the tribunal had in particular. The tribunal referred to the criteria that the belief must not be incompatible with the dignity of others. and the tribunal referred there to the enormous pain that misgendering can cause for trans people. And secondly, the tribunal referred to the criteria that the belief must not be incompatible with the fundamental rights of others. And there, the Employment Tribunal acknowledged that trans people have been bestowed certain rights by law, including the right to legally adopt a new gender if certain criteria are satisfied. As I say, the second case is one which is probably more widely known about, and that was a case which involved the claimant arguing that his ethical veganism was a protected characteristic under the Equality Act. And what some people aren't aware of, because it hasn't been widely reported, is the background to this case. So what are the facts that led the claimant to the door of the Employment Tribunal? So I'll just briefly talk about those. The claimant in this case worked for the League Against Cruel Sports, and he identified quite quickly into his employment with them the sources of investments that pension fund contributions were invested in, and he identified that some of the organisations whom his pension contributions were invested in potentially didn't have a good track record when it came to animal rights. So he highlighted this concern to his manager, and his manager was allegedly fairly dismissive of the concern. And so he escalated things by sharing this information with his colleagues and encouraging his colleagues to stop their pension contributions. He was dismissed for this behaviour. It was alleged by his employer that he had failed to follow a reasonable management instruction and had also strayed into the territory of giving independent financial advice to his colleagues. And the claimant argued that his dismissal was because of his belief in ethical veganism. So, as sometimes happens in cases like this, the tribunal separates out the question of whether the belief is a qualifying belief under the Equality Act and considers that first before then at a separate hearing going on to decide whether the reason for the dismissal or the discrimination is the belief or is something different. So in this case, only the first part of that process has taken place, and the Employment Tribunal decided that ethical veganism was a philosophical belief under the Equality Act. And they said in particular it was worthy of respect in a democratic society. So what will happen now is the Employment Tribunal will go on at some point, goodness knows when, to consider what the motivation for the dismissal of the claimant was. Was it, as the employer alleges, in the sense of it being the claimant's behaviour which led to him being dismissed, or was it his belief in ethical veganism? I suspect it's unlikely the claimant will succeed in this case, and the reason why I say that is that there's been quite a lot of other Employment Tribunal judgments which have considered the distinction between religion on one hand, which is a protected characteristic under the Equality Act, and then on the other hand, the manifestation of those religious beliefs in a way which amounts to misconduct. And the tribunals have been quite clear that those two things are distinct from one another. So while somebody can't be dismissed for holding a religious belief, they can be dismissed for the behaviour which might arise as a result of that belief if it falls into the category of misconduct. Okay, and then finally we have a couple of indirect discrimination cases, and both of them interestingly relate to no beard policies, but in quite different contexts. The first, hospitality, and the second, the police. So in the first case, we had an employee, or an individual I should say, who was seeking assignments through Elements Personnel Services, which was an agency providing staff to high-end hospitality establishments. And Elements Personnel Services had a policy which required individuals who were being put forward for these assignments to be clean-shaven. And this wasn't suitable for Mr. Sethi because as a Sikh man, his religion required him not to shave his body hair. So on that basis, Elements Personnel Services refused to put forward Mr. Sethi for any assignments with their clients. Now, interestingly, the evidence which came out at the Employment Tribunal was that the purpose of the policy wasn't anything to do with hygiene. Instead, it was seeking to uphold high standards of appearance. And it also came out during the Employment Tribunal hearing that actually some of Elements clients didn't have a no beard policy. And Elements hadn't made any inquiries with their clients who did have a no beard policy as to whether they would make an exception for a Sikh man who had a beard for religious purposes. So the tribunal found quite easily that the no beard policy was indirect religious discrimination. Clearly, it had more of an impact on Mr. Sethi as a Sikh man because of his religious beliefs than it did have on other categories of the workforce. So then the crucial point was whether the policy could be justified, and the Employment Tribunal found that it couldn't be justified. The reason for that was that when balancing up the discriminatory impact on the individual versus the business need, the employer's argument really just did not stack up. Obviously, the discriminatory impact on Mr. Sethi was significant. He was essentially denied the opportunity to be put forward for assignments, and the justification of Elements Personnel Services was weak, in that some of their clients didn't have a no beards policy, and even amongst those clients who did, inquiry should have been made to find out whether they would make an exception. So the tribunal's view was that this blanket no beard policy, which is a bit of a shortcut in order to avoid the agency from having to have those conversations with their clients about the possibility of Mr. Sethi being put forward. The second case, as I say, is a different context. The organisation here, which was the police service in Northern Ireland, had introduced a no beard policy in order to ensure that staff could be deployed at short notice to deal with situations which might require them to use respiratory protective equipment. And this equipment apparently is only effective if somebody is clean shaven. So Mr. Downey refused to shave off his moustache. So actually it wasn't a beard that was the problem here, it was a moustache. And as a result of that, he was redeployed from the armed response unit to the road trafficking unit. So quite a change in his duties. And he alleged that that was an act of indirect discrimination. And he came at this from the perspective of arguing that the policy was indirectly discriminatory in respect of men, because clearly the requirement to be clean shaven affects more men more than women. And the justification again here was something that was considered in detail by the Employment Tribunal, and again, unfortunately for the respondent, their reasoning didn't quite stack up. The factors that the tribunal took into account when reaching that conclusion were that, first of all, the team who would have been carrying out the response to the incidents that were contemplated hadn't had any training on how to use this equipment. So actually they couldn't be operationally deployed anyway. And also the canisters of oxygen that were attached to the respiratory protective equipment were out of date. The tribunal also took into account the fact that although a quality impact assessment had been carried out, it was 5 months after the policy was introduced before it was done. So these two cases serve as quite a good reminder of the need to carry out effective equality impact assessments. And really what those involve are just trying to identify in a proactive way before you introduce a new policy or practice whether there's any section of the workforce that might be disadvantaged by that. If there is, then thinking about alternatives. If there aren't any obvious alternatives that would achieve the same outcome, then thinking about ways that you can mitigate any discriminatory impact on the affected group. Okay. So that takes us to the end of our key case section. What I've done here is just give you the website address where you can find all of our most up-to-date advice in relation to employment law related coronavirus issues. The guidance has been updated regularly by our team at Law at Work. We're paying really close attention to every single development which is occurring on this, and trying to make sure that we can pass on the latest information to you in a very easy to understand and quick way. So I would suggest that anybody who has any questions about coronavirus has a good look at that, because the chances are you will find the answer to your question there. The challenges that you're experiencing are probably pretty similar to the challenges that lots of other organisations are experiencing. So hopefully you'll find that information useful. And of course, for our clients, there's additional templates and styles and things on the client area of our website. Okay, so I'm just going to come out just now of the presentation and just see whether there's any questions. Okay, so I'm not seeing any questions there at the moment. So as I say, hopefully you can find out any coronavirus information that you need from our website. And for those of you who are our clients, obviously you are able to speak to the relevant employment solicitor as well. So thank you very much for listening today. I hope you continue to stay safe and enjoy your time working from home as much as that is possible. Thank you.